All right, welcome everybody. What a great crowd. I'm glad to see so many friendly faces in the audience. I really appreciate everyone being here for this very important issue. For those of you who don't know me, my name is James Quintero. I'm the director of the Center for Local Governance here at the Texas Public Policy Foundation. And we are, of course, hosting today's event, Dimming the Lights on Property Rights, a debate on short-term rentals in Austin. Now, this is a special event in a lot of ways. Not only do we have assembled here a very brilliant and talented group of policy experts, but we are, for the first time in the Foundation's history, hosting this event on Facebook Live, which I'm told by people much younger and much hipper than me, is a way for people to watch online and then interact with our group via questions submitted that'll be taken during the Q&A portion of our show. And then, of course, we are very, very fortunate to have Fox 7's Elizabeth Saab here to moderate today. She's covered the issue of short-term rentals in Austin very closely, done a lot of great in-depth coverage on the issue and how it's affecting real people. And a little bit more on our great moderator. Elizabeth is a native Texan who started her career in New York City at NY1 as a news photographer and field reporter. From there, she moved to a cable news outlet in New York where she wrote and edited her own stories. She was an inaugural member of the video team for The Daily, the first daily interactive news publication for smartphones and tablet computers. Her stories have aired on Fox News, Sky News, and local Fox affiliates across the country. If you would, do me a favor and help me welcome a very talented Elizabeth Saab.
Thank you so much. Thanks, James. Well, brave is a good word to describe me hosting this today. I'm brave to take this on, but nothing is more exciting to me than actually talking about issues that affect our community. So thank you to the TPPF for inviting me to moderate this debate, and I want to thank our panelists for joining us today. So before we get started, I would just like to ask everyone to silence their cell phones. And for those of you watching us on Facebook Live, I hope you're listening intently and getting ready to ask our questions because you get to participate too. So let's go ahead and jump right in. I'm going to introduce our panelists, and we're going to do something a little bit different. We're going to allow them to introduce themselves, and they're going to tell you a little bit about their position on the short-term rental ordinance. So first, I want to introduce Sloan Dean. He is the Vice President of Revenue Optimization at Ashford, one of the largest real estate investment trusts in the hotel industry. And to his left, we have Joel Rasmussen, the President and founder of the Austin Rental Alliance, one of the largest nonprofit vacation rental owner associations in North America. And on his left, at the end, we have Chance Weldon, who is an attorney with the TPPF here. So I'm going to turn it over to them and give them each a minute or so to introduce themselves and tell you a little bit about their thoughts on the short-term rental ordinance.
Thank you. First, I want to say thank you to TPPF for being able to be here and be represented on the panel. As was said, Ashford owns 140 hotels across the U.S. We own 14 in Texas. We own 3 here in Austin. And our position is we're not anti-short-term rental. We actually welcome competition. So the U.S. marketplace has about 53,000 hotels. We are part of the American Hotel and Lodging Association and compete against thousands of different hotels, bed and breakfasts every single day. So we are pro-competition. We're not big fans of regulation ourselves, but what we are supportive of is fairness in competition. And you may or may not know, hotels have a lot of different regulation that they have to abide by, none short thereof of American Disabilities Act. So you may or may not be familiar with it, but all hotels have to have accessibility, pool lifts, etc. Also, we have to comply with local tax ordinances. We also have regulation around life safety, So sprinkler systems, et cetera, so that if you and your family are staying in a hotel and there's a fire, that you're protected appropriately. Various health safety regulations. And I'm just here to offer a different perspective, not one of anti-short-term rental, but one of fairness and competition. Thanks for letting me be here.
Joel?
Good morning. My name is Joel Rasmussen. I'm the president and one of the founders of the Austin Rental Alliance. And it is a full-time, at times full-time volunteer position, not what I do in real life. But it has put me in touch with an enormous community of really phenomenal property owners here in Austin. And so our position in this has remained unchanged from the beginning of the conversation, which is that the members of the Austin Rental Alliance support fair competition. We support and have actually made it as one of the initial prerequisites tax compliance, that anyone that is operating a short-term rental has to abide by all local laws. What we do not support is the ripping away of people's property rights, as the current city ordinance has done. And so we're looking forward to a conversation about how we can bring a little sanity and really some data and logic back into this conversation, because there are a lot of really crazy things that have been thrown at short-term rentals that have absolutely nothing to do with the reality on the ground.
Hi, I'm Chance Weldon. I'm an attorney here with the Texas Public Policy Foundation. And that means that I get to wake up every morning and fight to defend people's constitutional rights. So it's a really great job to have. We represent a half dozen property owners here in Austin who own short-term rentals. We filed a lawsuit against the city of Austin challenging the constitutionality of a whole host of regulations on short-term rentals that were recently passed. I think we'll probably get into the details of that lawsuit a little bit more as the Q&A goes on. But before we get started, I wanted to have an opportunity to show you guys a little bit, a small video to sort of humanize the issue a little bit. It's really easy to get lost in the weeds of, what's constitutional, what's not constitutional, what's good policy and what isn't. But we just want to point out that these are real people that are affected by these regulations, and at the end of the day, these are real people that's lives will be changed depending on the outcome of this lawsuit. So
We'll get started. Chance, I want to start with you because I think, we're all looking at this, and as a reporter, I'm always asking questions and playing devil's advocate. So I think right now the short-term rental ordinance is in effect, and we know that the city council had voted to put a moratorium on the short-term STR2s, which is people not being giving licenses to STR2s, people not being able to rent their homes out while living somewhere else. But the fact is that the STR2s that are in effect are still operating. So, Chance, if you could sort of clarify that from a policy perspective about the ordinance and what the fear is here from your side about what's going to happen in the future.
Well, there are two things that are going on right now. First, the City Council placed a moratorium on new Type 2 licenses, but it also set a deadline for all Type 2s. In 2022, you will no longer be able to have a Type 2 license, which means you will no longer, even if you have a pre-existing Type 2 that you're renting out right now, in 2022, you will no longer be able to do that. But more importantly, as of today, right now, there's a whole host of additional regulations that are placed on all short-term rentals. Some of those, for example, say that no more than 6 people can be outside in the backyard, front yard, doesn't matter, at a short-term rental at any time. Backyard barbecue, backyard Bible study, sitting around eating dinner in the evening, grilling steaks on the back patio. That is illegal today, right now, under the City of Austin short-term rental laws. Additionally, more than 6 unrelated adults inside at a short-term rental, anytime, for any reason, is illegal and subject to a $2,000 fine right now under the City of Austin short-term rental ordinance. Additionally, any activity other than sleeping after 10 p.m. subject to a $2,000 fine. So while they haven't made it illegal to use a short-term rental in Austin, they're trying really hard to make it practically impossible. And I think that's essentially the same thing.
And Joel, if you can speak from your perspective, why is this detrimental to people who want to rent out their property?
Well, so, and I'm pushing against the momentum on this one, but part of the issue with this whole conversation is these really are not short-term rentals. They're furnished rentals. And that really has been confusing for those of us who own and manage furnished rentals to get swept up in this anti-STR conversation, because every one of the members of the Austin Rental Alliance rents their property out for periods of 5 days, periods of 50 days, periods of a year and a half. The distinction is that the property is furnished. And there has been a need from the beginning of time. There's always been a need in Austin for furnished rentals. What this law is going to do is make furnished rentals unavailable except at an extended stay America. So it's detrimental to people that come here seeking jobs. It's detrimental to traveling nurses. It's detrimental to people who live in my neighborhood. A lot of the people that stay with us rent from us because they're remodeling their house for a week and a half. And they want to stay in the neighborhood. They want their kids to be able to go to school. They want to have the same commute. And they don't want to live in a hotel for a week and a half. There has been a demonstrated need, there will always be a need for furnished rentals, and this ordinance is trying to address an issue, a very valid issue of party houses, by using a sledgehammer and taking rights away from property owners.
But on the flip side of that, Sloan, if you could talk about how this is impacting your industry.
Yeah, that's probably a question I get every day. You know, how are short-term rentals impacting the occupancies of hotels, and what does it mean for the lodging industry? You know, to be just frank, I'm not sure. It's definitely having an impact on the lodging industry, but there's not clear data. So that's part of the so our two biggest points is fairness and competition and transparency. There's really no transparent data from Airbnb, HomeAway, et cetera, in terms of the amount of revenue per unit that's coming in, even occupancy rates. I think that's one of the items the lodging industry would like to see, is a little more transparency on the reporting, but it just doesn't exist. I just want to be really clear, you know, sitting up here and being maybe a representative of the lodging industry, I would really encourage everyone to Google and look up. Penn State did a study on short-term rentals. You can Google Penn State short-term rental study. And they looked at several major markets in the U.S. Where we are, we're not anti-short-term rental, we're not anti-competition, but where you look at, this is big business. Airbnb is currently working on another round of fundraising to move to $30 billion company, okay? And their business model is predicated on access and ease of inventory. And so if you look at what this ordinance is really against, it's the type 2 rentals, which are commercial operators. So the Penn State study looked at major markets, Miami in particular, which has some commonality to Austin. 61.3% of the revenue in Miami comes from 7% of the listings on Airbnb. These are commercial operators operating hotels, you know, with various loopholes in the industry. These are not, and you have a very heartfelt story. I really do, you know, respect and you know, appreciate the American dream. We're not against families, you know, wanting to rent out extra rooms, et cetera. Where we are the people buying residential property, not zoned as such, not complying with ADA, not complying with health and safety regulation. And then renting those out and driving up rental rates in certain local markets. So if you look at Austin, there's actually data that 44% of the listings in Austin, so this has been published recently, are people who list either more than one unit, and 1/3 of all rentals are available 365 days out of the year. Those are commercial operators. Those are not people.
Can I speak to that?
Yeah, I'm going to let you guys jump in. You know, normally, again, I would be asking all the questions, but this is so interesting to me that I don't want to jump in and change gears, so by all means.
Okay, well, two things on that, and this is a little bit in the legal weeds, but the Austin Court of Appeals has ruled that short-term rental use is a residential use. It is compatible with residential uses. These are people that are staying sometimes for a week, sometimes for 2 weeks, in a residential home using it for residential reasons. They're eating dinner there. They're having friends and family over there. This is not a commercial use, just like renting a home for a month is not a commercial use. It's a residential use. And on top of that, the broader issue that our particular lawsuit is about is that you don't sacrifice your constitutional rights to privacy. You don't sacrifice your constitutional rights to free movement within the home. You don't sacrifice your right to not have a 10 p.m. bedtime as an adult simply because you choose to rent a home for less than 30 days. So the implication that just because Airbnb is a large corporation, that the people that are being affected by this are large corporations, I don't think is a fair characterization. These are families in a lot of cases that have chose to rent out a house. And these regulations apply whether or not they choose to do it through Airbnb or Craigslist or any other way that they decide to rent out their home.
So let me throw this thought into the mix, because a lot of these short-term rentals are in apartment buildings, and some of what I have seen and we've reported on is that the concern that some people have is that the people who live in these apartment buildings don't know who's coming in and out. Again, Joel, I'll throw this to you because you work with a lot of buildings. So how do you assuage those fears?
Well, this really started as an enforcement issue. Again, the position of the Austin Rent Alliance from the beginning is that we support regulations. We've been absolutely in support of licensing, and there is an issue in Austin with, and this is the issue, the assertions that there are companies coming in or that there are large investment firms coming in and buying up swaths of residential real estate and turning it into short-term rentals is, we have found zero evidence of that. What we have found evidence of, and this is pretty easy to find, is individuals who will essentially secure a bunch of property with leases, and then they will turn around without the knowledge or the permission of the actual property owner, and they will make those properties available as short-term rentals. We object to that in the strongest terms possible. It's not fair to the property owner, it's illegal, it is not fair to the other tenants of those apartment buildings. That is the particular activity that we object to and that we feel is probably what everyone should be objecting to. But an individual that owns a rental property that is available furnished, whether 6 months or 6 days, is not a concern to the hotel industry. It is not something that the city council needs to be stepping in and regulating.
But so what's the solution then because this is a large issue, and as you guys are saying, it's being blanketed, but so how do you suggest that you can regulate that more about who's coming in and out of the larger properties?
We had an effective ordinance before this current ordinance that I'll call round 2. We had an effective ordinance. The big gaping hole was a clause that was inserted that was called the testing the waters clause. So it allowed someone to advertise without having a license, and that made it effectively impossible for code compliance to be able to tell who was licensed, who are the good players from the people that are trying to fly below the radar. By removing that testing the waters clause and by actually having some teeth to the ordinance so that there are repercussions, you will actually be fined and be shut down if you're operating without a license, particularly if you are offering property that is not your own property. That takes care of the problem. There's no reason to do all of this crazy stuff that we've arrived at when the problem was party houses and the problem of people using property that is not theirs to make it available short term.
And I'd like to speak to that just briefly as well. The constitutional standard here, whenever you violate someone's fundamental rights, is that the restrictions have to be narrowly tailored to a fundamental government interest. There has to be a really good reason, and it has to be no more burdensome than necessary. And here, we found out in court yesterday when we had our hearing, code compliance isn't even on duty on weeknights after 6 p.m. So if the problem is party houses, and look, we have no problem with enforcing noise ordinances. Those ordinances are on the books. We have no problem with enforcing, regulations on parking in the yard or anything else that would enforce a problem with a party house or people coming and going. But the city, rather than actually, hire someone to enforce the code on weeknights after 6 p.m., they've decided to carpet bomb people's constitutional rights and adopt a whole host of ridiculous regulations, and in fact, ban type 2s altogether. And so, again, I understand concerns with having fair competition and a level playing field, but I think the solution in that case is to maybe perhaps do away with some more of the unconstitutional regulations as opposed to regulating everyone equally. Just make everyone regulated less.
Yeah, I think that's a fair point. I mean, if you look at the hotel industry, most of you probably aren't aware. I'll just go through the list quickly. We're required to get a permit for hotel tax purposes, collect and pay taxes, local, state, federal level. Obviously, Now Airbnb, et cetera, is handling the tax issue. The various hosts are paying those. Zoning requirements, health and safety codes, ADA, which is American Disability Act. Commercial, we carry commercial liability insurance, so if you slip and fall and hurt yourself in the building. Local and state fire permits, et cetera. If you talk to a bed and breakfast, so that's a mom and pop operation, they're required to go through the same regulation. And they actually compete the most directly with short-term rentals. Our argument is that 44% of the listings in Austin are commercial operators. And so I think it's powerful to put up families. And yes, we're not anti-type 1, type 3. Short-term rentals here to stay. It creates competition, which is a good thing. The challenge is that you have commercial operators, which is what's driving this industry, drives the majority of the revenue for the short-term rental companies. You have homes that are driving $700,000 in income a year in Austin. That's not a local resident making some money on the side to help with their mortgage payment. That's a commercial operation. And I don't disagree, you know, if type 2 should be zoned the same as residential housing, then we'd ask that our hotels be unzoned as commercial operations so that we don't have to do the various things that type 2 doesn't have, because it's not a fair competition. By not having fairness in the regulation, you're picking winners and losers.
Well,
Every word of that was disingenuous. Every single word of that. This is
I wouldn't
bed and
say that. I
breakfast
wouldn't sit here and
operations.
say you were disingenuous.
Bed and breakfast operations have staff. Bed and breakfast operations have different individuals who don't know each other staying under one roof. A short-term rental is a residence. It is occupied by an individual, by their families, by their friends. They have control over the whole residence. There is no staff. There is nothing commercial about the use. So you can continue to use the word commercial. There's absolutely nothing about the use. The courts have agreed with that. And logic, if you look at the activity that happens in the property, says this is a residential activity. What happens? People go and they do their dishes, they watch dinner, do the dishes, watch TV, have dinner, sleep. So I'm a little emotional about this. I get so wound up about this commercial label. It's wrong. It's disingenuous. This is a residential use.
So how do you have markets where under 10% of the listings are driving over 2/3 of the revenue in a marketplace?
Where's your data?
So the Penn State did a study that looked at Miami. 61% of the revenue is coming from 7% of the listings.
I don't know Miami. It's a holiday destination.
The regulation that's been instituted in New York, in Chicago, in San Francisco, where actually short-term rental was incubated, is actually more stringent than what has been put in place here in Austin. So if you look at other municipalities, a lot of the country is actually now introducing legislation that is more stringent than what exists now here in Austin.
So
And
do
those
you,
regulations are
so
failing.
keeping it though here in Austin, because that's a good point, we did want to touch on what other cities are doing. So before we get in a debate over what all these other cities are doing, keeping it here locally in Austin, the reality is that the short-term rental, as of now, type 2, as far as the city council is concerned, is going to be phased out. So again, Joel, I just have to go back to you, and everybody else can jump in, but you maybe have a good pulse on what's going on in the rental community. If these short-term rental 2s are eventually phased out, do you see a black market?
Of course.
So can you talk about that a little bit, how that will start to affect the city?
Well, there's a black market right now. I mean, if by using the term black market, you're talking about people that are operating without a license, there's an enormous black market right now. And with the amount of revenue that the city could be making by making regulations easy to follow, by making the tax, I mean, there are cities, for example, Los Angeles just announced a partnership with Airbnb where they are going to collect the taxes. That's where the city should be putting their efforts, because this is an activity that is growing exponentially. So I'll share some of our data. There was and I apologize that I don't have the specifics, but when travelers in the United States were asked whether they were going to choose a short-term rental, it was a very small percentage. It's actually much less prevalent in the US than it is in Europe. I think it was less than 20%. But what jumped out at us was the people who had done that for the first time were overwhelmingly going to choose that as their lodging option the next time that they traveled. People like the convenience, they like the privacy, they like having laundry and a full kitchen. So it's a use that people are demanding.
So,
And if there is a demand, there will be a supply for it.
so then to Sloan's point, if there is that supply for it, then why not, as a group, try to adhere to some of the regulations that hotels are being?
Because these are not hotels, these are residences. And the thing about a short-term rental is that the use is flexible. Someone may decide to have the property available as a short-term rental, and then it goes back to being their full-time residence. It's a home that is governed by the zoning laws, the same as every other property. And there are regulations, the same, again, this is the frustration with this idea of short-term rental, because they're not short-term. Sometimes they're short-term, sometimes they're long-term. The distinction is that they're furnished. And the laws that apply to a long-term furnished rental are the laws that apply to a long-term unfurnished rental. There are no additional laws that are required. For what reason? The use is not any different. When you have staff coming in, when you have people that don't know each other, when you have large gatherings, suddenly you have the need for ADA compliance, you have the need for additional regulations, not for a residential use.
And I'll let our other panelists jump in.
And to that point, I think that the thing that gets lost here a little bit is there's a lot of talk about, whether or not there's fair competition or what regulation should be in place. But at the end of the day, this is about fundamental freedoms. This is about if, I decide to rent out my house to somebody, should there be a host of very strange and very draconian regulations that are placed on me and my renters? I mean, it's still my house. I'm still renting it out to somebody. If I decide to rent it out for 29 days, I'd be subject to a whole host of regulations. If I decided to rent it out for 31 days, all of those regulations disappear. Okay, so it's about the freedom of people to enter into contracts with one another. And I would add one more thing with regard to the regulations that are in place against hotels versus short-term rentals. Right now, under the City of Austin's ordinance, code compliance can come in at any time, any reasonable time, and search a short-term rental without a warrant, without probable cause, without exigent circumstances. It violates the Fourth Amendment. And the United States Supreme Court last year held that it violated the Fourth Amendment against hotels. So this is something that is unconstitutional if you do it to a hotel, yet someone's home that, again, like Joel mentioned, may be a short-term rental one weekend, maybe someone's home the next, maybe next month it's somebody's home. The government agents can come in at any, quote, reasonable time and search it without limitation. And that's something that doesn't apply to hotels. So that, again, it's just another example of how these things aren't being treated like homes, and it's not fair, and it's not constitutional. So.
Yeah, when it comes to, I think regulation, if there is regulation and enforcement is going to be really difficult. I mean, they're seeing that in San Francisco and New York, that enforcement is a challenge. But just because something is hard to enforce doesn't mean regulation shouldn't exist. I mean, that's the same argument as we shouldn't have speed limits, because a lot of people speed and a lot of people don't get caught. Okay, that's hard to enforce is not an argument for not having appropriate regulation in place. And again, I come back to, we're not against type 1, type 3, we're not anti-short-term rental. We're fairness and competition is the whole argument of the lodging industry. And when you have people owning entire homes, having them listed on short-term rental sites 365 days a year, and driving a disproportionate amount of the revenue that Airbnb gets from a certain marketplace, that is not somebody who owns their residential home. It's a place they live, and then renting it out at their convenience. I think there is a disingenuous argument from the other side that's saying that these are the majority of the people, or people who are renting out an extra room in their house, etc. We're not against that. If you look at a lot of the data that's been studied in markets, I don't have any data specifically around Austin, but if you look at Miami, Chicago, San Francisco, where their study's been done, a disproportionate amount of the revenue going to the site are from homes that are multi-unit owners that operate 365 days out of the year.
So then let me ask you this question, because what happens if somebody owns a home and they lose their job and have to move into an apartment and use that home as income for them while they are looking for another job and trying to supplement their income. As Austin continues to become more expensive to live, what do you say to those people?
Well, part of the reason Austin's becoming more expensive to live is, you know, what people don't realize, and David King, who's part of the housing community, couldn't be here today. I'm speaking on behalf of the lodging community. But if you look at rental rates as well as home values, this is driving up home values.
But what do you
certain
say to
communities.
those people? What do you say to those people who are renting out, and I'm playing devil's advocate, what do you say to those people who are renting out their home and living in an apartment so they can supplement their own income?
No, I like I said, I mean, if it falls into the category of this is part-time business, this is a type 1, type 3 rental, we're not against short-term rental in that capacity. I think it's more of the commercial operators. So, you know, we're not part of the legislation or part of the lawsuit. I think, you know, my position would be that's up to the local regulation. But, you know, where we have a problem are the commercial operators that are buying multiple units. It's not the individual family who has, you know, hard times and is trying to make extra income. And I would argue that is disproportionately a small portion of this industry.
I think this is a classic example of where the government comes in and imposes land use regulations that make it more expensive to live in Austin. They raise taxes and they make it more expensive to live in Austin. And then when the market adjusts for that and people try and find a way to deal with it, these imposed costs and these higher costs, then people that want to regulate come in and scream, hey, what you're doing might be raising the cost of living in Austin, when the government was the one who created the problem to begin with.
So before we just, you know, have a couple more minutes before we open up to questions, let's take a few minutes to talk about solutions. I mean, obviously, this ordinance is here, and how it evolves is obviously up to the city council, but as stakeholders, how do you see, for example, Sloan, where the commercial operators are regulated, but there's also the opportunity for people to make the extra income if they need it? We'll start with you. Solutions.
Yeah, I think you do one of two things. There's, you know, fair that both sides, type 2, as well as hotels, are regulated in a similar fashion, or some of the regulation that applies to hotels is lessened. So there just needs to be a level playing field. It's that simple.
We had an effective ordinance. We had an effective ordinance with one giant flaw, which was the testing the waters clause, which made it impossible for code to enforce. By removing that, that was all that the city needed to do to have an effective ordinance to require people to be compliant with hotel occupancy tax, to require that they have a license and post that license visibly so that everyone knows that the property is licensed and in compliance. That was all that was necessary. This incredible overreach of taking people's property rights away, of violating their constitutional rights to privacy, that has to go away. And if it doesn't happen of the council's own volition, then I think it's going to happen in the courts.
But what specific advice can you give the city council as they move forward to help craft an effective ordinance for all sides?
We've given them our advice. They're uninterested in it. Our advice is that they had a very effective ordinance, and all they needed to do was close that loophole. Enforce the laws that are on the books. This conversation started because of party houses. That is a valid complaint. No one wants to live next to a property that is being taken over by bachelor parties every weekend. That's not a fair use of the property. That's not fair to the neighbors living next door. Enforce the existing ordinances that are, you know, that take care of those problems. And for this, you know, for short-term rentals, if the city's going to regulate it, they need to make those regulations easy to comply with.
My advice to the city council would be to stop violating the Constitution, you know, just to begin with. And it's funny because we were in court yesterday, and for the first time ever, they actually came in front of the court and they filed a response, and they said, guys, we didn't really mean it. We're not going to enforce the ordinance. So you guys probably shouldn't get an injunction against us. And for the injunction purposes, the court bought it. But my advice would be to stop violating the Constitution. Perhaps we could try freedom for a while and allow people to enter into agreements. And look, there are valid noise ordinances on the books. There are ways to stop party houses. There are ways to restrict these things. And my advice to the city council would be, you know, perhaps you hire some code enforcement officers. They have 4. And perhaps you enforce these ordinances rather than putting it on homeowners to try and enforce these things themselves, because that's just not fair.
So I know we have a couple more minutes, but I want to open it up to questions because I did see some hands up in the air. I want to just some housekeeping. Before you ask questions, they're going to come to you with the microphone. If you wouldn't mind, say your name and we'll just kind of go around the room. And also who you're posing the question to. So could we see like the hands up and we'll start moving around. Ma'am, we'll start with you.
Hey, I'm Carol Price. I have a company called Under the Texan Sun, and I have 4 vacation rentals. None of them, Sloan, get close to 700,000. I'd love to know where you get that statistic. I've seen David King put that one out there. I have tons of friends in the ARA. No one is making that kind of money, so please stop saying that. My question for you is, have you actually seen or looked at the 311 reports, to any of you? Because I've taken it upon myself to look at the 311 reports every month, and they send them to me. And last month, as in the month before and the month before, over 90% of the complaints were for unlicensed regulators, not party houses. Occasionally someone's complaining because the trash can is out for an extra hour, and the problem is that the city is not enforcing what we already have. And so if you look at those statistics, how can you say that, well, I kind of lost my train of thought. I don't understand how you can defend the fact that hotels are the same as houses when the problem isn't that we're not trying to be licensed, trying to be legal, is that we're just trying to get the city to comply with the rules that they already made up.
To answer your question directly, I haven't seen the reports that you reference. You know, obviously every unit's not getting hundreds of thousands of dollars, nor are we own hotels that don't even make money. You know, we actually have hotels where currently we're not even cash flow positive. So it's, you know, people look at it and say, well, these are large institutions. They're, you know, they're worried about their way of life. But no, we've dealt with new competition. I mean, online travel agencies entered the industry and created a whole new competition. We're all for competition. Like I said, I think from our perspective, it's just fairness. I mean, we have to go through so much regulation that costs us a lot of money. I mean, very specifically, there's a new law out that we didn't agree with that says we have to have pool lifts at every single pool and spa that are fixed, and they're very expensive for handicap accessibility. It costs us millions of dollars. Those don't apply to you know, it applies to bed and breakfasts as well. I recognize that, yes.
And an 88%, they're not going to choose my properties. So they're going to choose your hotels because that's their choice of being able to go somewhere that fits their needs.
Yeah, so you're
Come to my hill house by the very virtue of this federal
right.
So I can't make my hill house ADA compliant. Why should I?
Well, it also depends on, I mean, if you're only renting something occasionally, that's not what, you know, a lot of the lodging industry has issue with. I mean, if you're just renting it a couple months a year, that's not what we're talking about.
But why would the
Full
safety
time.
issues be any different for 7
I mean,
days
if you
a
have
year?
if you have something available full time, how's that different than just being a one-room hotel? How's it different?
First of all, God forbid there's a fire in my place, they can go out my windows which are compliant, but in a hotel which is on 10 stories up, I can't go out the window. So you gotta go down the hall.
We have hotels that are one-story buildings.
So in the effort of just allowing everybody to get a question in, maybe we'll save this conversation for, hang on just a second. I know we're all passionate about this
I was just going
issue,
to add.
but
I was just going to add one thing. We did crunch the numbers as part of our lawsuit, and in the past 4 years, there were 74 noise complaints against licensed short-term rentals, and only 11 of those were verified. So I just wanted to throw that out there. We did crunch the numbers. To answer your question.
so, sir, who's next?
I want to
Sir.
make one quick distinction. I think for the last 3 years or so, the city of Austin does require ADA compliance for all new home builds. So the distinction, I'm hearing ADA is an argument against comparing hotels to housing. It is now required for housing, just not to existing homes. They're not requiring people to retrofit their homes. All new construction requires ADA on all new homes. I believe that to be the case here in Austin.
So, anybody else questions? Questions, sir? Well,
Actually, we have
Oh. If you could stand up and say your name, please. Thank you. And who you're asking the question to.
My name is Ahmad Zatari. I'm one of the plaintiffs in the lawsuit against the city. My question is for Sloan. I heard you say something about the type 2s raising the values of homes in Austin. Is that right? Did I?
That's something that, several of the housing associations make that argument. It's a pretty common point that's been heard. I think several of you, I think somebody referenced David King.
Were you aware that it's only the type 2s are bound to 3% of the census tract? So basically when you apply for a type 2, there's a certain amount of licenses. Once those expire, you're not allowed to have a type 2, right? So in my area, for example, there was only 5 or 6 left when I applied. So how is that really raising the value of homes? I mean, I just don't see, because when we say something like this, we really should have the facts. I just want to encourage you to do that.
I do. I have them right here.
Like,
I have the MLS from last year. In the last 365 days, there were 11,388 residences sold in Austin. There are 417 Type 2 licenses. That is statistically impossible to have any effect on the real estate market.
I think, the point that I would come back to is that it's fact, okay? 44% of all listings on Airbnb currently are someone who either owns a multi-unit, so owns multiple units and have it listed, or have it available 365 days out of the year.
have you verified that they actually own those or they manage them for other people? Because the system, and let me just educate you on Airbnb. If you become a superhost, you become your friend's best friend, right? What happens is your friend wants to use your account to post their house. So are those, like when you're looking at these numbers, are you saying that you verified that every single one of these people actually own those homes, or they just are managing them? That's another question I have.
Well, if they're managing them or not, it's available 365 days out of the year. How is that any different? It's not occupied by anyone. How is that any different than operating a hotel?
Fair
It's
enough.
zoned residential. We have to go through all kinds of regulations for commercial zoning. How's that any different regardless of who owns or operates it if it's available 365 days a year?
I can tell you exactly how it's different. It's a residence. It is a residence. What happens in the property is residential activity. There's nothing commercial about renting a property, whether you stay there long-term or short-term. The only difference is whether they're paying for the utilities and there are dishes in the cupboards.
So
It is a residence. The use is residential.
So in the effort of moving this debate along, before we
I have
continue
one more
taking,
little
hang
thing,
on,
if you
before we
don't
continue taking questions from the audience, let's take a couple from Facebook and Twitter, because those folks have been so kind to join us on social media. And then we'll get back to questions from the audience. I want to, on Twitter, Jim Bradbury is asking for our panel to please address the rights of the adjacent family property owners. Who wants to weigh in?
I'll start with that. An adjacent homeowner absolutely has the right to be free from noise. They absolutely have a right to be free from being woke up at 3 o'clock in the morning because Animal House is going on next door. They absolutely have the right to be free from trash, people parking in the yard, gunshots, any other sort of ridiculous public nuisance that could happen. That's their right. But what they don't have the right to do is to tell the person in the house next door that they have to be in bed by 10 p.m. That's not your right. It's not your right to tell people who can be in their house to visit and have dinner. Your right as a neighbor does not extend that far. And that would be my answer.
Okay, and then we've got a thought from Josh Daniels on Facebook. Again, either Sloan or Joel, you guys can take this on since we had a chance to answer the last one. Why is it, or why should it be legal for local government to discriminate between the rental of a home for 29 days and 31 days? In my mind, the fundamental use of a property in many cases doesn't change just because it's rented for 2 nights instead of 200 nights. The health, safety, and welfare implications are already covered by other ordinances that deal with parking, traffic, noise, and event total occupancy limits. The mere length of stay is being targeted as creating a whole additional issue here. Do you guys agree with that?
Absolutely. If someone rents my property for the month of January, there are no limitations versus any other rental in the city of Austin. But Sloan's argument is if they rent my property for the month of February, I now have to be ADA compliant. I have to have additional zoning restrictions. I have to have all of the same regulations in place, including escape and fire and all that a hotel does. For the month of February, why is February different than January? It makes no sense.
And Sloan, can you counter that?
Well, I guess to counter Joel's point, I mean, what would prevent then commercial operators to unzone their properties? We would save a tremendous amount of money and run them as short-term rental properties that are available.
What commercial operators? What are you talking about?
So what would prevent us, we own a hotel, what prevent us, like we own Lakeway Resort on Lake Traps.
Because a hotel is a commercial enterprise. You have staff. You have multiple people staying under one roof that don't know each other. You have all of the different concerns that happen when you have business that is taking place, and you have staff and employees and everything that's involved in it. That's not what a residence is.
So someone who's got a home that's available for sale 365 days, there's all types of short-term commercial operations that are associated with that. So
you're just going to
Well,
keep
let's get back
repeating
to
that word.
Let's get back to Josh's question on Facebook before we keep arguing over commercial and not commercial. I mean, well, he's making an interesting point about, the fact that up to a certain amount of days, it's zoned one way. After a certain amount of days, it's a different way. I mean, why, his question, again, we'll pose it to you, why should it be legal for the local government to have a say in how that changes?
From
one day to the next.
Yeah, in terms of the number of days, I couldn't speak to. I mean, I don't know why 30 was chosen. I think that's something that's healthy to debate. What's the number of days that someone should be, allowed to rent something before it's considered in commercial? It's a fair question. I don't, particularly have an exact answer for it.
I have an answer. It's not legal for them to distinguish between 29 and 30 days. The United States Constitution, the Equal Protection Clause, says that if you're going to treat two things differently, you need, at a minimum, a legitimate state interest based in data to support it. So unless the city, which it hasn't to this point, can point to actual facts that show that there's a compelling reason why a home rented for 29 days is fundamentally different than a home rented for 30, then they don't have the legal right to do it. It violates the Constitution.
Oh, gosh, we have more questions from the audience. Sir, you were so kind enough to wait. If you wouldn't mind saying your name and who you're asking this question to, please.
My name is Richard Sly. A couple of things have been neglected in this, quote, debate, one of which is the property rights of the neighbors. I don't know how many people in here have lived next to an STR2 that's used as a party house or a multiple gathering. I've had several close by in the neighborhood. The right of the neighbors for use of their property, quiet and peaceful enjoyment, is destroyed. My other item is, I'm in real estate. If you've got a operating, quote, hotel next door to your house and you want to sell it, what do you think happens to the value of your real estate? Who's going to consciously buy a house next to another house that's operated as a commercial establishment and has hundreds of people a year going in and out of it?
Joel, can you answer?
Also, Joe, I think you need to look up the definition of residence. Quote, Webster is where people live, not where they short-term stay.
I couldn't agree more with your first point. And that's why from the beginning of this conversation, we have supported regulations. And in round 2 of this conversation, we stood at City Hall and we stood side by side with Councilmember Gallo, with the mayor, and we said party houses are not acceptable. They need to be shut down. Code needs to enforce the ordinances, and they need to make sure that the rights of neighbors are not violated. No one should have to live next door to a party house. I couldn't agree more. I couldn't disagree more with your second point, because and I understand that you've had a traumatic experience living next to one of those properties. They're a very, very small portion of the number of short-term rentals that are operated in Austin. The overwhelming majority of short-term rentals, you would never know that it's a short-term rental, because it's not a short-term. I'm speaking right now, sir. you would never know that it's a short-term rental because the activity that's happening in that property is there are human beings residing there. Whether they reside for a weekend or for 3 months, what's happening inside that property is that there are people doing people things in a house. In terms of what happens in the real estate market, we've also looked at that extensively. We have found a couple of realtors who are in the ANC camp, and they're very fired up about this issue. We found absolutely no statistical evidence whatsoever because, again, you wouldn't know that the property is being operated as a short or long-term rental.
Sir, I would just like to speak. I'm very sorry that you had to deal with whatever it is that you've had to deal with short-term rentals next to your property. And I understand that a lot of that there are properties that are unlicensed out there that could be a problem, that a party house is a problem. And there are absolutely regulations on the books to deal with that. And it is a shame and it is ridiculous that there are 4 code compliance officers in the city of Austin to deal with that garbage. And I'm sorry that that's the case. But what that doesn't give the city council the right to do is carpet bomb people's fundamental rights to come in and tell people that we're going to come in at any reasonable time without a warrant and make sure that everybody's in bed at 10 p.m. So I think what the city's done is you have a legitimate concern, is what I'm saying.
Well, what you're doing is combining 2 separate issues into one and using the argument for one against the argument of the other. There is no problem with short-term type 1 rentals that we see. The problem is the commercial operation of a hotel with no management, no supervision, next to a residential residence. Why do people buy a house in a zoned residential area? Because it's single-family zoned residences, not a hotel.
Yeah, so two points. First, these regulations regarding the 6-person cap, these regulations regarding warrantless searches. All of those regulations apply to an STR1 and an STR2. So all of those things that the city council passed that are arbitrary and violate the Constitution, those apply to STR1s and STR2s. Also, you referred earlier that this was a so-called debate. And we invited people from the city council to come here today. They didn't send anyone. We invited people from the neighborhood association to be here. They originally agreed and then backed out. So
I'm on the board of a neighborhood association right in the middle of it. I never got an invitation.
I think we had over 50 invitations out, and I'm sorry that we didn't get in contact with your group. And as a matter of fact, in the future, if we do hold one of these things, then if you want to get in touch with someone in the back, we'll make sure that we can contact you in the future.
So in an effort to move this conversation forward, thank you for bringing up your points because they are obviously very valid. But in an effort to move forward, we do have a couple of other questions from the audience. I saw some hands over here. Yes, ma'am. And if you could say your name and who you're addressing the question to.
My name is Carol Ickelkamp, and I am a taxpayer here in the city of Austin, and I do pay my hotel tax as an STR Type 1 participant. But Chance, I have a question for you. You made a statement, and the statement you made, it questions the integrity of my city council and of code compliance. You said that they came to a hearing, and if you will reiterate for me so I don't have to go get the transcript of that hearing yesterday, you said, we're just kidding. We're not really going to enforce those ordinances. Can you address how that kind of flippant comment came about and what I might be worried about with an upcoming election of my city council?
Yeah, absolutely. I will address that. And it was a flippant comment, and it was because it was a strange reaction from the city attorney. We filed a motion for injunctive relief, and for those who aren't familiar, that means that before a hearing is held on the merits in a trial, you go to the court for emergency relief, and you say, pending a trial on the merits, we want to enjoin the enforcement of this ordinance. And one of the things you have to prove at an injunction hearing is that there's a real threat that the ordinance will be enforced against your client. That there's a real threat that it'll be enforced. And so we moved for injunction. We said, look, these things are unconstitutional, Your Honor. We want them enjoined until we get a full hearing on the merits. The morning of, literally an hour before the hearing, the City of Austin city attorney filed a response. And the second page and third page of that response were a list of stipulations where they said, the City of Austin will not enforce this ordinance against renters because our client in the sought injunction was a renter. Therefore, there is no risk of enforcement. We went down to the courthouse. We got a code enforcement officer up on the stand. We said, Here is the statute. Here's what the statute says. It says it applies to guests. Are you telling me that's not the way the statute's read? And the code enforcement officer says, that isn't on the face of the statute. That is what it says. But we don't enforce it that way. And the city attorney promised that she's not going to enforce it that way. And the judge said, on the basis of that, I'm not going to enter the injunction. But I tell you what, Ms. Hebert, who was our client, he goes, I tell you what, Austin City of Attorney, give her your home phone number, and if someone comes out to enforce it, you give her a call. Okay, so that's what happened at the hearing yesterday. And so yes, the city basically said, in the flippant way, I said, yeah, we didn't really mean it with our crazy unconstitutional ordinance.
Let me take it to Facebook. We've again, thank you for joining us on our Facebook Live streaming. We do have another question from Facebook, and this is from Ben Wilterdink for Sloan specifically. To achieve a level playing field in the market, do you think that the lodging industry should push for exemptions and or repeal of regulations for hotels rather than attempting to force those regulations on short-term renters?
That's a really fair question. It's a good question. You know, as a father, I would say there's certain things that, you know, I think are appropriate. You know, having sprinkler systems that are life safety regulated, if you've got families in hotels and, you know, God forbid a fire takes place. You know, so I think any commercial operator that's, you know, has families, et cetera, rolling through should have, you know, basic life safety items. So I think there's certain things like life safety that are appropriate regulation. Absolutely, when it comes to certain things, I referenced ADA that several people chimed up and said new properties have to be ADA compliant in the residential community. You know, these pool lists that are unreasonable, et cetera, the lodging industry was very anti against. So it was regulation that was excessive. You know, and the mandate for every single property to have these pool lists that never get used was an example of, yes, we are over-regulated. So I think there is definitely an argument for should the hotel industry, and the hotel industry is spending a lot of its effort of, you know, we think there is a lot of regulation that exists against us that's unfair. So I think that's a great question. I mean, currently, the way type 2s, you know, without any type of regulation, it's basically allowing folks to pick winners and losers. You know, because you have bed and breakfasts that have to go through all these you know, jump through all kinds of hoops for regulations, some of which we totally disagree with. And then you have type 2 short-term rentals that have very limited regulations. So you're effectively picking a winner by not leveling the playing field. But to be direct, there is definitely regulation on the lodging side that we disagree with, and in many cases think is overregulated. And I think that's a great point. And this just isn't part of this conversation. The lodging industry is working to try and resolve the overregulation that exists in certain municipalities.
Yes, ma'am, in the back here. Oh, yes, hi.
Hi, my name is Rob Wilson. Thank you all for coming and hosting this. Two quick questions. One, for those of us who are just learning about this issue, can you define type 1, 2, and 3? And secondly, we talk about the fairness of competition for the providers of the lodgings. What about the fairness of competition for those looking for lodging? In other words, why should we have to always have the government saying, this is a safe place, this is an improved place, this isn't, when we can just say, yeah, I don't care that that place is regulated, you know, that it's a nice place, I want to go there, the price is right, and I'll take the responsibility.
Those are two great questions. I'm going to actually ask Chance if he could define the 1, 2, and 3 just from the policy perspective, if you don't mind.
Right, so a type 1 short-term rental is what they call an owner-occupied. And the way that's been enforced by the city of Austin, however, is that it's someone who claims the property as a homestead. So when these things are rented out, the owner's not there. You know, they rent out the entire unit. So it's not like they're renting out an extra bedroom. A type 1 could be completely empty, just as likely to be an animal house as a type 2. Type 2 means that you don't claim it as your homestead. So, and you know, as it's been pointed out, some of these things are available 365 days a year. Some of them aren't. Some of them were originally someone's home, and then they had to move into an apartment, like our clients. So that's a type 2. And then a type 3 is something that's a multifamily use. So again, these are going to be things like apartments, condos, things like that being used as short-term rentals. So I think that is what you asked.
And I'll ask the other panelists to jump in on question 2.
It's an interesting parallel to me to the recent conversation about, I hate that word TNC, but the transportation network companies, so Uber and Lyft. I'm absolutely baffled because in that situation, everyone that was getting into an Uber did so willingly, and everyone who was driving for Uber did so willingly, and yet our city council stepped in and said, nope, this is not okay, we need to impose all these additional regulations. I don't have a logical answer for you, but I would much prefer the latter, where I'm free to make my own choices and walk into a contract with eyes open.
And yes, Sloan, if you could
I
address
think it's
that.
a great question about customer choice, right? And, allowing the customer to choose, et cetera. And like I said, I mean, we are not anti-competition. We are not anti-type 1, type 3. And even with type 2, we just ask, because they're operating very similar to us, and sometimes in a verbatim fashion, to be treated similarly. But absolutely, I think that's a great question, and the customer should have various options in different marketplaces. People, often say, well, how's this different than the Uber argument? Well, you have an industry in short-term STRs where in a lot of markets, a disproportionate amount of the revenues are going to a small number of operators who are listing things multiple times a year. Uber is predominantly getting most of its revenue from, a huge number of operators. And it's also against an industry that was very stagnant in the cab industry, and in a lot of ways had different duopolies and lack of competition. Just about every hotel, bed and breakfast is owned by a different entity. And the largest lodging company is now Marriott Starwood, and it's 8,000 hotels worldwide. So you still have a lot of customer choice. And absolutely, I think Airbnb, HomeAway are great business models and have created a lot for the consumer, and we're not against that.
We have time for a couple of other questions. Ma'am, I saw you had your hand up in the way back there for a while. Thanks for being so patient.
My name is Dana Chen Fisher. Thanks for defining the type 1, 2, and 3. So this question is to Salon. So type 3 is not owner-occupied, but multifamily units, including renting out the whole dwelling. So how is your position to type 3 different than type 2?
Well, where we have issue is just anyone that is running a commercial business and is zoned not as such. In terms of the different types, anyone that fits in that category, which has been explained to me that is the vast majority, if not all, of the type 2s. That's why I keep referencing type 2. If there are type 3s that fall into that same category, that's maybe me not being up to speed on some of the type 3 categories. I would just simply say, regardless of the type definition, if you're operating multiple units available 365 days a year, and that is not your primary residence, and it's zoned as residential, and you're operating like a commercial business, we have an issue as it relates to fairness and competition.
And just to clarify, just factually to clarify, so the city, for those of you who are not aware or up to speed as much on short-term rentals, the city has put an ordinance on those type 2 short-term rentals, which means you do not live in your home, you live somewhere else, but you rent your home out. And so the idea is that they've put a moratorium on that, and they are on issuing those licenses, and they have publicly said they are looking to phase those types of short-term rentals out. So that's sort of what this focus of this debate is over, is this type 2 short-term rental and its longevity.
But to clarify, type 3s are also not occupied by the owner, and most of them are available 365 days a year. They just happen to be in a multi-family structure. So it really is a curiosity, because there is a moratorium on type 2, non-owner occupied. There is no moratorium on type 3, non-owner occupied in multifamily.
So with that clarification, ma'am in the green, I believe you had a question. Also,
I mean, just to clarify, you know, the lodging industry would then have, so it's my fault for not being specific, would have issue with certain types of type 3 as well. So it wouldn't just be the type 2s, that it's anyone who's got something available 365 days, that is not in any way a residential property for them. That's where we have a fairness argument. So thanks for clarifying.
I've always wondered.
I'm sorry, would you mind saying your name and who your question's directed to, if you don't
My name
mind?
is Joyce Howell, and I guess I would just address it to probably one of you gentlemen. I've looked at the list of Airbnb and Vrbo and all of those, and there are so many places that are listed. And when I see the number of people who have actually obtained a license from the city, it doesn't seem that those two match up. So I've wondered, you know, why hasn't the city gone into their those lists and done a cross-reference and done something to eliminate that?
Are you implying that the government might be sloppy and not do its job? Because I think that's the answer. I think that at the end of the day, it's a lot easier to pass a huge regulation than it is to actually go and enforce the existing ones.
Sure, to have more regulations rather than to
Enforce the ones that are in place.
But I do want to address the issue that I had talked about earlier, where we had an ordinance that was passed. There was a stakeholder process. We sat down, neighborhood groups, short-term rental owners. It was not easy, but we all came to something that more or less everyone could accept. And then at the 11th hour, there was a third party that pushed in this clause called the Testing the Waters Clause that allowed people to advertise without a license. And that, you know, until just this year, that made it effectively impossible for code compliance to be able to look through Airbnb and VRBO and see who's licensed and who isn't, because there was no requirement to post your license. That's the reason that we're having this conversation. The reason that we had a breakdown in the pre-existing ordinance prior to version 2 is that it wasn't practical for them to be able to see who was, you know, to weed out the good players from the bad. Now they have that, but council, in addition to solving that one problem, has placed all of these additional onerous and unconstitutional requirements on top of that.
Yeah, just to add on, I agree. I mean, I think enforcement's a real issue, right? Regardless, you know, what you've seen in other industry is, you know, other industries have taken upon themselves to do some self-enforcement when there's regulation that exists. You know, maybe that evolves to that extent, but I mean, if you look at Airbnb and VRBO and HomeAway and you really understand their model, you know, they're obviously very supportive of, you know, no regulation, you know, minus they've agreed to pay taxes in municipalities. So I agree. I mean, I think enforcement is a challenge. And like I said before, just because something's hard to enforce doesn't mean you shouldn't have a level playing field.
So I think we have time for one or two more questions.
Hello, my name is V. Wynn. I've done Airbnb for 3 years. I got my license 3 years ago, pay my hotel taxes. I have one that was a type 1, and then I also have a where I don't have the homestead there. And so I understand both sides of it, but I think you're not addressing what, like, this gentleman down here was talking about, is why is the city pushing this, right? You blame it on the city that they're not doing these things, but I've even had code compliance go to me when my license didn't renew. They worked well with me. So I haven't had a problem with the city. The city is under fire because of neighbors that are concerned about what their neighborhood looks like. And so when you talk about, you know, 30 days or less than 30 days, right? You're saying, oh, 29 or 30 days, right? But that's not really it. 60% of occupancy rates, that's the occupancy rate in Austin, right, for Airbnb. And why is that as low? Because we're a festival-heavy city. So people come here because of the festivals. So the neighborhoods are actually more upset because these are visitors that are coming in, tourists that are coming in, versus 30 days or more is because they're the potential Austinites, right? They're the people that are coming here.
So, and I'm the reporter here, so I'm not taking sides, but I want to share with you as a reporter who has covered this extensively, we too requested the 311 calls. And it seems, and don't quote me on this because I don't have the numbers in front of me, I wish I did, to what your point is, there are citations being issued. They're just a little disproportionate to the number of 311 calls that are coming in. But to your point, to go back to what you were saying, and I want to just take a few more minutes if we could sort of delve into this a little bit deeper, as to your point about a home that's been cited many times. If those people were to put their home up for sale, how does that help the homeowner in their sale, selling their home, or the neighbors? What does it do to the neighbors' value? And I think that's a valid point that is worth just exploring a little bit.
I want to address that, and I think it is a valid point, and I want to address it for this reason. When the government decides to regulate something, it has to use the way of regulating has to be tied to the problem. Okay, and so there is a problem. There is a problem with unlicensed short-term rentals that are party houses that create problems for neighbors. That's legitimate. And I feel for people who live next to these houses. And the city of Austin absolutely has the authority to regulate party houses. And no one's saying that they don't. Okay? But what they've done here is they've adopted a whole host of regulations that are, in fact, in some cases ridiculous. Like saying you have to be asleep indoors, even if you're dead silent, by 10 p.m., okay? And so the city didn't have the right to regulate that way. And ultimately, the reason that you have regulations that get passed like this is because if you increase enforcement, that costs money. You may have to, God forbid, raise taxes, move other spending around. It actually forces the government to do something, and it forces everyone who pays for government to feel that pinch equally. But whenever the government creates these regulations, the people who feel the pinch are the ones that own the short-term rentals. So the people that are being harmed are much smaller, and so they can target them. And that's what picking winners and losers in the economy is all about, and that's why it's unconstitutional. And so yes, I fully understand why there are problems, and I fully sympathize with people that have to deal with that. And I wish the city of Austin would do something to enforce existing noise and police power regulations, but they haven't done that. They've decided to do something fundamentally different, and that's why we got involved.
So, you've had your hand up, ma'am. Name and who you're addressing the question to, if you don't mind.
Hello, my name is Shereen Fisher. I have a property management company, and we have management of about 40 short-term rentals, give or take the time of the year. So first, I want to thank everybody for being here. Sloan, in particular, you have a voice I have not yet heard on this discussion, and a valued one. But I do want to make a couple comments. So one, as a property management company, I do manage type 1, type 2, and type 3, so I'm familiar with all. And there should be some distinctions between them, but there is also a moment in time where the home is rented and the owner is not there regardless. But I also want to go to the commercial use versus residential use. I love to stay in hotels with my husband. I love the amenities, the great restaurants, the pools, the daily housekeeping, the fluffy towels, all of those things that come with it. And I also greatly value staying in a vacation rental home. We just left one last week. We didn't want a single person other than our family there, and we cooked all our meals together and had family time. So I don't know if you've ever stayed in a vacation rental home or not. But I do want to point out, I've never stayed in a hotel room where I haven't locked my door at night. I have never stayed in a vacation rental home with my family where I locked my door at night. I have never hesitated to walk into the lobby of a hotel, but I wouldn't bear to walk on the sidewalk of a vacation rental home without permission. I would always knock to go into a vacation home, whether they were there for 2 days or 30 days or 6 months. So I don't think they're the same. So with that said, can you envision a scenario where you do see a level playing field for the hotel industry, the bed and breakfast industry, and the vacation home industry that is perhaps tiered, or items are applied in what I feel to be a fair and reasonable manner? Because a lot of these short-term rentals, type 1, 2, and 3, make their short-term revenue under 50% of the occupancy, so putting in $1 million chairlift into a pool would be financially devastating to a residential home. So could you see a tiered system or something where you're not holding it to the hotel standard, but not necessarily to a 12-month unfurnished rental standard?
Well, thank you for being here too. And, you know, great to hear your perspective. I think you have some great points. You know, I'm not an attorney by trade, so what is, you know, is possible in legislation, I'll definitely give my opinion, and, you know, Ashford's stance that I think there's a reasonable ground. I don't know the details in and out of the legislation that exists in Austin and then the lawsuit against it. And we're for reasonable, fair business practices, okay? And there's a lot of regulation that we have to abide by that we don't agree with. I think I've referenced that multiple times. So what that balance is, I don't know. I think that's why this is playing out in so many municipalities. I mean, this is really a top 3 or 5 topic for just about every major city. And I think people are struggling with it. It's the balance of, and I feel for you as well, you know, the housing issues that it could cause, fair business practices versus hotels. I know I'm dancing a little bit here in terms of giving you specifics, but I think there is a balance to treat hotels, bed and breakfast, and short-term rentals. And there may not be a blanket statement that they're all treated exactly the same.
Being in the industry for a long time, over 10 years now, I would love to see you as a partner, not an adversary. And so if we can, and same thing with the neighbors.
Yeah.
So any point that we can come together on common ground and devote the energy and effort to those discussions, I think would be immensely valuable to all of us, rather than some of the negative banter that seems to consume.
Yeah, no, I absolutely, totally agree. I mean, actually, Ashford, you know, TPPF, I think we've been involved with them on other items. So I absolutely agree that you know, there's some common ground. You know, what that specifically is, I wouldn't be able to say, but I think it's a great point, not being unreasonable in business practices and what regulation exists. It's a really fair point.
One more question right here, ma'am, in the black. Yes, go ahead. Well, 2 more questions and then we'll wrap up. This is such an interesting debate. I could talk about it all day and not go to work if y'all want to do that.
Cynthia Reynolds, I'm a short-term rental owner, type 2 and 3, also a real estate agent. I have long-term rentals and short-term rentals right next door to each other. Half of the duplex is long-term, half is type 2. How can, either constitutionally or from your viewpoint, how can we regulate my long-term rental next door differently from my under 30 days sometimes and over 30 days sometimes on the other side that happens to be furnished? How can we separate those two and say these regulations exist for this half but not on this half when the use is exactly the same going on both sides of that duplex, for example?
Joel, I want to give you the opportunity to weigh in. I've heard from...
Well, I think my position on that is pretty clear. There is no difference in the use, so there really can't be any, there can be no constitutional legal basis for treating those properties differently. What happens when the tenant closes the door behind them is exactly the same. So they have to be treated under the law in exactly the same way.
Sloan, your thoughts?
Yeah, it's a great question. You know, I think it's one that I wrestle with because I'm a consumer too, right? And back to your point, I have used vacation rentals. I didn't mean to address that. And I actually have used Airbnb before to get the experience with my family. You know, I think it's a fair question and challenge. I think that's what's playing out now. I mean, how do you treat this different versus someone who's just renting it long term? You know, the way we look at it is our business is to rent hotel rooms short term to multiple people, and when something is, you know, walking a similar fashion, you know, that their customers are coming and going, that it's behaving a lot like a hotel or a lodging experience. And so some of those regulations that apply to us should apply to them. Or if you want to get rid of some of the regulations, we would be supportive of that as well. I mean, we're just for fairness. I think you have a very good point, though. It's a one that should be debated. But very good point. I don't think I have a clear-cut answer to answer it.
And really, the very last question. You've been so patient to wait, and then we really have to wrap. So we'll take your question.
Thank you all for being here, and thanks for TPPF for the postings. My name is Suzanne Pike. I own a property that is homesteaded. In answer to the gentleman here in blue, I'm sorry I forget your name, and your answer to him is there's another classification, there's 1A. And 1A is someone who has more than one dwelling, if you will, that is somehow attached either on the land or to the houses, and I'm one of those owners. I have a 1A. I do have support for type 2s. I always have, I always will. I think it's unfair if my house was one lot over from me, that I would be treated differently and poorly by the city as a 2 instead of as a 1A. I understand neighbors' concerns, and I understand some hotel industry concerns. However, I have to object to being compared to a bed and breakfast. When food service becomes part of the package, everything changes.
Do you have a question?
I wanted Sloan to address.
Yeah, that's a fair point. We own hotels that don't have food services. They're select service hotels, extended stay hotels that don't offer food services. So I wouldn't, unfortunately, offering food and beverage is not a zoning requirement for a hotel. We own hotels that all they are is a sleeping room. We have no food services whatsoever, unfortunately. So that I appreciate your point, and I think that's an argument maybe versus bed and breakfast where they have food offerings, but we own hotels that offer no food. I mean, it's just a sleeping room.
Yes, but even the hotels that don't offer food have staff, they have cleaning crew, they have employees, and they house multiple different people who don't know each other under one roof. So to your earlier point about, walks like a duck, sounds like a duck. It's not. It is absolutely, you cannot draw a correlation, even if they don't serve food, between a hotel and an individual residence.
So I'm going to jump in because obviously this debate is going to continue to rage on for so many more months. So I'm going to let you hold your thought for the next debate, if you don't mind. Thank you so much to our panelists and the TPPF, but most importantly, thanks to you all for joining us and to the folks on Facebook Live and on Twitter who joined us, because obviously we could not have this conversation without you all. So thank you so very much. We appreciate it.
Thank you, Elizabeth.
Thank you so much.